My name is Tara Whalen, and I am thrilled to be here for my first ShmooCon. And after the opening talk that Marsh gave about paranoia and the government, I have to admit that I do work for the federal government. Except I work for the federal government of Canada, so I hope that makes it okay. I'm an IT research analyst, and I work at the Office of the Privacy Commissioner of Canada, and I'm going to be talking about some recent issues around Wi-Fi, particularly the Google Wi-Fi issue. So 2010 was an interesting year for wireless privacy and security in general, as I'm sure you all know. We had lots of stories about base station spoofing on cellular. There was some wireless tire pressure sensor hacking attacks going on. We had the fire sheep issue in the fall. And I mean, even the talks today, we had several interesting wireless hacking research going on out there. Our office keeps a close eye on this. We're very interested in technology and privacy. But the particular wireless issue I'm focusing on in this talk is the Google Wi-Fi issue. And this was the case where the Street View cars were collecting inadvertently wireless payload data. Now, I do have a couple of caveats to lay out. First of all, this is an open investigation from our office, so I do have some limits in what I can talk about, but I have tried to give you a lot of interesting information in this talk. Number two is I'm not a lawyer, for good or for bad, but I'm very happy to take any legal questions back to our lawyers and get information for you, but I'm going to talk about the technology more so than the law. So I'll bring you a little bit back to the beginning of the story. So April 2010, and this comes out of Germany. They had some questions about the collection, mostly of the SSIDs and MAC addresses. So they'd been hearing that when the Street View cars were doing their imagery, they were also mapping the access points to improve their location services. And the Data Protection Federal Commissioner, Peter Scharr, was, well, as he says here, I am appalled. He wasn't aware this was going on and wanted more information about this. So Google gave a response, and they provided some information to several national data protection authorities. So that's the sort of role that we have in Canada, looking for privacy as a data protection authority. And they said, well, here we're going to give you some clarity about what we're doing. We're collecting this information to improve our location services, to augment GPS cell tower location information in several ways. And this is the important segment of this letter to look at, which is they stated that they can receive all data. However, all data payload from data frames are discarded, so it never collects the content of any communication. So this is the important fact to keep at the back of your mind, dated the 27th of April. Very short time later in May, so the Hamburg, we're still in Germany, data protection supervisor wanted to look a little bit deeper and went and had a visit and looked at one of the cars and noticed that the drive wasn't there and asked them about viewing the drive. And they said, well, you wouldn't be able to read it anyway because it's encoded, but he really wanted to know a bit more and pressed them to look into what was on the drive, do an audit, have a look at what kind of information you're collecting and storing. So they did that and had a little bit of a closer look at what they had been collecting and storing on the drives. And when they said we weren't collecting the payload data, what they actually meant is that maybe they were collecting some payload. So as it turns out, 600 gigabytes had been collected in 30 different countries because some experimental code that had been developed by an engineer had been mistakenly included in the scanning software that was included as part of the Street View project. So it hadn't gotten the full review, had wound up in the scanning software, and that was vacuuming up the payload as well as the header data. So the response at that point, on the 7th, they grounded all the Street View cars while they had a little bit of a look further. They segregated the payload data that had been collected, and a week later there was the public announcement. So the blog post came out and laid out the case, and they talked about how, yes, although we had said we did not think we had been collecting the payload data, in fact, this was a mistake. It was now clear we had been mistakenly collecting samples of payload data from open, so non-password protected Wi-Fi networks. But again, they didn't use it in the products, but they were unaware of that. So the 14th, this came out. And what was the response? Well, there was a lot of outrage. Certainly there was a lot of news stories about people being quite surprised. There was a lot of debate back and forth in the technical community about the ethics of this. how it differed from war driving. Did it differ from war driving? But overall, a lot of outrage and debate. Lawsuits as well came out. I believe some of them are still running in the United States. And there were also some formal investigations by the data protection authorities, and that was including one done by us. So as far as Canada goes, I do thankfully have a bit of an inside scoop on this one, as I was the technical lead on the case, so I have a few details about this one you might not get anywhere. June the 1st, the Office of the Privacy Commissioner announced we were going to do an investigation. Within about a week of that, independent of our investigation, Google released a report from a third-party software review. So what they had promised to do was to have an audit of the code that was in the cars doing the wireless scanning. And so they brought in Strohs-Friedberg to do a report. Then that was released publicly, and that gave a lot of us who were interested in the issue the first technical look at what was going on in the code, so we could review that quite deeply to get a good sense of the nuts and bolts of what they were doing. So after we reviewed all the information we had available, on July the 19th, the techies from the office, that's myself and my colleague Andrew Patrick, went down to headquarters. In this case, we went where the data was to have a look at the information where it was being stored. We think we were probably actually the only data protection authority to make a visit to Google to do an investigation on site in Mountain View. So a few nitty-gritty details, at least from the Canada side. The Wi-Fi data was about a year's worth of data that was collected, and it was 18 gigabytes in Canada. And I have a little asterisk on there. That's because of the border issues. Whenever there was any driving going on close to the border, there's probably a bit of American data in the Canadian data and a bit of the Canadian data in the American data, just for those places that are really close to Detroit, for example. So it's not absolutely positive. You can't positively separate every single segment of it, a little bit of overlap. And in the data set was 6 million VSS IDs of various devices. So our role in this is about finding out about personal information. So our office looks about information about identifiable individuals. This is under the law. So we have a law called the Personal Information Protection in Electronic Documents Act, PIPEDA. And it says that there's different kinds of information. And so business information, so anything to do with business addresses isn't in this category, but your personal residential information would be. And IP addresses we have put in the category of as potentially being identifiable information. So can you link it to a person? And definitely things like content of communications if it can be linked to a person. So this is the kind of material we were trying to find out, was this collected? I mean, given the amount of data, I think we can all make guesses as to whether you would think this information would be in there, but it's a different matter to actually verify it. And one issue we came up against was that the payload data hadn't been read by anyone at that point. So when the cars were grounded and the data was segregated, that data hadn't been used by Google. They'd put it away and really didn't want anybody looking at it, because this is now full of personal information potentially. So we didn't necessarily want to make things worse, of course, by going in, drilling down into the data, and then being the ones who then read all the personal data that nobody had looked at up to this point. But again, we still wanted to verify the facts of the case. So what we decided to do as our approach was to verify the types of personal information collected. So we have different categories, and we said, okay, we'll go in and verify the fact as to whether or not that's there. We'll look up a few examples. In this case, we said 5 examples, and we'd say yes. So then we definitely know that there's email addresses in there, or we definitely know there's home addresses in there, and then we'd stop looking. And we took very high-level descriptive notes about this. So we didn't take notes about this is the name of the particular individual and where they live and collect that. We just said, no, there's a name and an address. This has been an instance. We'll note it and move on. Another quick note about the data. We noted that comment earlier from Hamburg about saying you wouldn't be able to read it anyway because it was encoded. This is what they're talking about, is that they'd stored the data in the serialized format. They used the Google Protocol Buffers format. So there does need to be some processing to get it to be human readable and for you to run any of your regular expression searches on, for example. In this case, Google provided the decoder, which sped things up considerably so that we didn't actually have to do that step ourselves. Then we could go straight into the processing of the data. What I think is this is probably the first time that anybody at the Office of the Privacy Commissioner used the command line in an investigation. It's almost certainly the first time probably anybody rolled their own code. I mean, we really are talking a lot of regular expressions searching, you know, lots of the Perl, a lot of grep, that sort of thing. But I'm thinking this was a precedent-setting investigation for us. So we did a lot of searches on the data looking for particular header fields, particular keywords to identify the particular pieces of interest, and then did some manual verification. So we were eyeballing to see whether or not this instance was an instance of personal information. So what did we find? Well, not surprisingly, lots and lots of headers. So lots of email headers with the email addresses in them. Lots of HTTP headers, so that will, of course, give you all the IP addresses. It'll give you usernames, URLs, so we can tell where people were browsing. Lots of cookies. So I mentioned Firesheet briefly, and of course, people were having all their sessions hijacked because of cookies being sent in the clear, and certainly there was a lot of evidence of lots of cookies being sent, and we saw that early on. Certainly there were contact details that were in there as well, and entire email messages. Now, some of the early communications from Google stressed that they said they were just going to be fragments because we're driving down the street and we're doing channel hopping, and so probably it's just going to be tiny little pieces. Well, sure, there were lots of small pieces, but not exclusively pieces. There were definitely entire start-to-finish communications in that data set. And I'll just note one password somebody put in an email. They were telling someone how to get into their server and just gave them the username and password and sent it along. A couple of more problematic ones. One not as bad. Someone had sent an email about a particular speeding violation. So when we were looking up information about home addresses, this happened to be there. The reason the home address was in there was it was information being sent about who's been speeding, and here's where we saw the incident is being sent to your home address. So probably a little bit personal in the communication. And there were, the one that was more problematic was a set of records. Again, we were looking for address information, and we found names and addresses and associated sets of medical conditions, and there were several of these records. So that was probably what we saw as the worst instance. And bear in mind, we were doing what we considered to be a surface scan and not a deep drill down into that, and we still sort of tripped over something quite sensitive fairly quickly. So then we took all that information, what we had seen, and we took our notes and went back to our own office, and we worked with some other investigators who then issued what they call the preliminary letter of findings, which is when you give your response to the organization or agency that you have a complaint about. And this was on October the 19th. And what we had said is that the complaint is what we call well-founded, which is to say there is some substance to this under the law. And I'll note a couple of pieces that, from the law that we used in making the determination. So the first was that, I'll just note this isn't really about intent here, is not what we look at. We look at what actually happened, not what their intent was in doing so. And we have an idea in our law about knowledge and consent. So you have to get someone's consent before you would collect the information. Of course, this was inadvertent, and they didn't get anyone's consent. So quite easily it becomes, well, there was no consent to collect this data, even though you didn't intend to collect it. Similarly, they didn't identify any purpose for collection because they had no purpose in collecting it and didn't intend to. So number two, there's no identification of purpose. And similarly, they didn't limit their collection to a specified purpose because we didn't have a purpose. So 3 points under the law very quickly said, yes, you have indeed contravened this part of the law. But I will stress this was mostly about the process. We were more concerned about how the mistake happened. How was it that this piece of code got in there in the first place so that data was inadvertently collected? Because that's a much bigger problem. How did it happen? How do we prevent something like that from happening again, either there or in another organization? Because these are often case studies that are used from other agencies for coming up with best practices. There were a few errors in this case that led to the epic fail. When the code was developed, there is a place when they do a design review where if you believe that your code has some kind of a privacy implication, you indicate this. And then it's supposed to go to review to another group. And it was indicated, and it was made the mark, but it was never brought to the person to do the review. So they didn't actually follow the existing process in the first place. So that was the first place where we had a problem. But then there was no check to catch that. So there was no review that happened. I'll also note that the proportion of data that was collected compared to the large amount of image data was so small that you wouldn't necessarily notice you were collecting a bunch of extra data piggybacked on what you had because it was really so small. So no one was going to notice it. They weren't looking to have this data, and it wasn't like suddenly the amount of data they collected had tripled, and we better look into that. So no one was going to trip over it without actually doing a formal audit. So this was a place where you really needed the process in order to catch what was going on. So what we really did at the end was we said, we have a set of recommendations then based on this incident. We want there to be more privacy training for staff, because if someone can tick a box and then not follow through in the next step, then maybe there's an issue there. We suggested that they go towards more of a governance model. So what that would do really is put more process in place to catch some of these problems when they happen. So you're detecting your privacy issues, and that you have some individuals who are responsible, because usually that's much better way of being sure that the process is followed when somebody knows that it's their responsibility and someone knows who to go to when they've got questions and concerns. And of course, we want them to delete the Canadian data. And I'll note that there is a deadline. We're waiting on response. That's just around the corner, February the 1st for full implementation. But in the meantime, about 3 days after we issued our preliminary letter findings, there was a response on the blog. So I'll say this is not what we would call official correspondence, but this did appear on the blog about 3 days later, and they had 3 items that they decided to talk about putting in place, and one involved training. And so training was that they were having enhanced privacy training, and it had been rolled out now. It's December 2010 that all new hires get privacy training. And we've moved to a sort of governance model with compliance. So now the engineering project lead has to maintain a formal privacy design document to catch, again, some of these problems so they don't disappear on. And people responsible for privacy. Well, Alma Witten is appointed Director of Privacy for Engineering and Product Management. So it looks like the things that we asked to put into place maybe already haven't been rolled out. And I'll also note that, of course, we don't work in a vacuum, because I mentioned there's other data protection agencies. This one we found kind of interesting. This is in the UK. So this is, I just grabbed a snapshot from one of the sort of tech papers. And in July, the office in the UK also was looking into this, and they'd said we didn't actually, we had to look at some samples, and we don't think that there was anything there that was personal data. And that was probably not long after we had done an investigation and thought, well, unofficially, it's hard to imagine that we would have gotten the results that we got after looking at the data, and that you had looked at your data and not found anything, unless perhaps all of the networks in the UK are all locked down and protected and everyone is really, really careful. I couldn't really quite reconcile that result with the result that we had had. But then we released the report, and less than a month after that, this is an item I pulled from the BBC News, they said that, well, after inquiries, including the Canadian commissioner who offered a lot of detailed information, then the deputy commissioner admitted that, well, we didn't really do a really thorough investigation. And after we've looked at what the other data protection authorities did, well, now we've actually changed it to a significant breach. So the fact that we did the in-depth investigation sort of caused a little bit of a change in stance across the pond. And I'm going to do a little topical footnote to the end. So today actually is Data Privacy Day. So happy Data Privacy Day to everyone. Yeah. So it's go Egypt. Yes, it is definitely a good. So it's a good time to reflect on tech privacy issues. We have a lot of technologically savvy people in the audience here. And as we've definitely found, I mean, all the year round, we are looking at technologically complicated privacy policy issues. And you really do need to have that strong technical component in order to deal with a lot of these issues. And it's really, really helpful, and it was keyed in this investigation to have people working on the team that had that technical expertise, and it's incredibly useful. And I expect that when we get to the keynote, that Mudge is going to have some interesting things to say about his experience in taking his technical expertise into a government department. But I definitely will stress that there's lots of good, interesting policy work out there for people who are technically minded, and it's, I think, only going to become more important as we go on. I will open the floor to any questions that people have. Also point out that I'm available all through the conference. The whole reason I'm here is because our office is very interested in maintaining those close ties to the security community, to the privacy community, to technology generally. So I'm here to talk, but I'm mostly here to listen and to learn from what's going on with these great tech talks that are happening. So anytime, either at the conference or later, we're open to hearing what is on your mind. So my email address is there. We do maintain a blog at the office, and we will periodically put up technologically minded blog posts there about refer headers and wireless privacy and you name it. We also are on Twitter. It's not me personally, but it is the office, and we will pop up items of interest either from our lab or stuff that we found interesting on the feed, so I recommend that you go and follow us. And with that, I will open the floor to questions, and thank you for your time. Good question. So the first was, under Canadian law, is there an expectation of privacy if you leave your wireless network completely open? So expectation of privacy is a little bit thorny. We do have our Charter of Rights and Freedoms, similar to your Bill of Rights, does talk about things like similar search and seizure and expectation of privacy issues. But in this case, the networks were open. What it was in this case, it was being collected because your information was being collected by a company. So that because we have this law, the one that I mentioned, the Pipeta one, it has to do with commercial use of information. So it'd be a little different if it were not a commercial entity that was collecting the information. So you may have an there's a distinction there, though, if you are looking at the content of communications as well. So are you intercepting communications of any kind, no matter how you are doing it, is one aspect of the law. There's another that has to do with whether or not, so that's the question of whether war driving, if you're just mapping networks, for example, is that okay if you're just a private citizen? And that's actually, you're getting into a very thorny legal area, and the back of my mind is saying, I think I'm taking this back to the lawyers to try to get a clearer answer for you. But whether or not it's open or whether you've locked it down doesn't necessarily put it into one camp or the other immediately. It's a little more complex than that. The second question was, I'm gonna. If I take my. Yes, if you put your name in your SSID. So you say that this is John Smith's network, which is an interesting question. It was one that we were wondering about, because if you took one step back and said, well, what if you weren't collecting payload? What if you were just going around like people do with war driving and you're just mapping? Suppose you were just doing one of the open source hotspot maps that you were doing and you were marking those down. Would a person's name in there be considered personal information? I'm, as not a lawyer, willing to say that possibly there's some consideration might have to be made, that you can then say that that's where that person lives. Yeah, that's.
You drive by and they know where your car is and they take a picture of your house and you have your name and your address number right there. Is that any different than the email that you found with the address in it? Where's the separation?
The separation between whether or not because yeah.
Have fun with that.
You're no. It's a really good question, because it comes down to how far away, in some sense. So if you can walk up in front of the person's house and get the information about where they live because their name is on the mailbox. Of course, in this case, the assumption would be that they've deliberately put their name on the mailbox.
Right, but they drove by and they took a picture of the house as part of Street View. So
yes.
They digitally collected
yes.
that information.
Yes. And indeed, there are lots of challenges going on for Street View as well, even separately from the wireless issue, that there have been, particularly in Europe, have been questions as to whether or not they are able to include some of these pictures, in the database to begin with. Oh, sorry.
I've got a question about the intent. The news reports I've read of several national investigations seem to have taken at face value Google's statement, we did it by accident. If any government had a similar situation with on, let us see if we can determine whether or not it was by accident. Was yours or any of the other government investigations asking the question, can we confirm it was an accident?
The question about whether or not it was an accident more spoke to, again, said we're going back about process more so than intent. So our investigation wasn't really looking at that so much. I couldn't speak to some of the other data protection authorities. I think some of the details I've seen from some of the lawsuits that have been brought are talking more about that intent, particularly if they are looking at damages, because again, there's this idea that you're supposed to have some kind of malicious intent, and that there was some kind of damage done in order to have some kind of collection. It's an interesting point you brought up about whether or not it would be considered to be more or less trustworthy if it was a government versus whether it was a business is an interesting one. And I certainly have had people asking whether or not there is any how strong is the indication that indeed it was a mistake, whether or not we had enough information to go by that say that we definitely. So there wasn't, what I would say is there wasn't any evidence to suggest otherwise from our perspective.
Would these kind of concerns go across any sort of radio transmission? If Google had a radio scanner and was recording ham operator conversations that were intended for them, would that also be a violation?
Yes, because in this case, it doesn't have to do anything to do with that particular medium. It has to do with collecting the information. So the law is more principle-based. It's deliberately broad, that it can be interpreted. So the idea is it wouldn't necessarily matter how the information was being transmitted so much as it was collected in this sense. So it's more about the collection of the information and less so about how that particularly happened.
So it would be illegal to record those conversations?
Yes. Yes. Oh.
So this all seemed to take place with a lot of, friendly cooperation with Google. They're providing, the code so that you can process the data and all. But I'm wondering, so you prepared this report, but you didn't want to keep any of the evidence because that had PII in it itself. So I'm trying to figure out what the legal sort of force is of the report, given that you don't keep any evidence to back up your claim that there was all these things in there, if you don't want to keep it.
Right. Yeah, so we're getting back into, well, I wish I had brought a lawyer with me who would be very happy to bring this question. I think I may need a follow-up.
Like intent, because if you wanted to say you guys did this, you have to change, and they could turn around and say, we didn't do it, where's your proof?
Now, because the other, I guess, wrinkle that happens occasionally is there's jurisdictional issues that come to bear. So, I mean, I will say in this case, yes, we did have fair spirited cooperation between the two groups in this case. So that made things a heck of a lot easier. But it can get a little messy with jurisdiction as to whether you say, yes, you are, for example, allowed to come in and to collect information. Then there were questions about with moving the data or taking the data across borders or taking it back. In this case, we also are an agency that tends to be more of an ombudsman so these laws that we have, they are more about mediating, and we don't have, for example, the ability to levy fines or anything, so we don't have those kind of very, very strong regulatory powers. So in any event, we were going to be limited to the degree to which we could force an issue. So that, in some sense, facilitates our ability to collect information and come to an understanding with what we found and have them agree with our findings than it would be if we had to bring it into a court of law with some kind of if we had to do some kind of forensics and some level of evidence. It would have been quite a different question, but it tends not to be, it's not the way that we operate or haven't operated up to now.
Probably also helps you avoid being subpoenaed for the lawsuits because of what you have.
That's because we don't have it, that's right. Oh, we have more questions over there. Okay, so the question was there that about whether or not the information had been read, and of course, it's a very good point. What is that they had made statements that it had not been read and that they had segregated it, and particularly as they had not been intending to use it in any product or had no use for it, and it didn't seem to have had to show up. But that is not to say that we have evidence that it had not been read.
My question is, since
Oh, I don't have those numbers for you. It's a really excellent question. The question there was, so do we know what proportion of the Canadian networks were open versus those that were locked down? Because they only would have picked up things that were from the open networks, and I don't have the numbers. I think there may be some people who do collect that kind of information or do periodic audits of a certain area, and then from sampling we'll try to figure out. But I don't have that number for you. Sorry. Oh, more questions in the back. Okay, so this question was, so did we run into a case where Google was the secondary problem? What it was is there was a company that was, for example, transmitting information that was being picked up by Google. That was almost, I mean, in a sense, a lot of the data that was being transmitted is going to be either individuals or companies, but we did not look at who the sender of the information was, so we did not do any secondary investigations of a company based on the Google information. Okay. Well, I think I'm right on time, and I want to make sure that the keynote speaker goes. So thanks for your excellent questions, and look forward to interacting with you throughout the conference.
And once again, filming provided by www.mediaarchives.com and mediaarchives.tv.